there's no death penalty as such in Hong Kong. The capital crime which attracts life imprisonment in Hong Kong is murder. But in addition to murder, another offense also attracts life imprisonment, that is torture. But torture is an unfamiliar area as far as I am concerned and as far as my colleagues are concerned, because we do not recall any conviction based upon the conviction of torture. So this is really an unfamiliar area. The only thing that we are familiar with about torture is the so-called torture appeal claim, because for people landing in Hong Kong, resisting repatriation to their home countries on the ground, that there will be a risk of being tortured, could be a ground to resist repatriation. As Bijou Francis earlier introduced to you some articles of CAT, of the convention, that is under Article 3, those state party has a duty not to repatriate or return or extradite those people who have substantial grounds to believe that upon return to their place of origin, they may be subject to torture. So in fact, many of the lawyers here, many of my colleagues, are actually involved in a scheme assisting those seeking this sort of, you can call it, not asylum as such, but claim against repatriation. And of course, we have a certain procedure on that, which of course, considering time, I can't go into detail. But suffice it to say that, in fact, torture is not a familiar area in Hong Kong, thankfully. But I think it's not by accident that there's no, issue of torture here. I think we have to look at our system, our judicial system, our legal system as such, to find out why torture is almost unheard of here. I'm not saying that the police in Hong Kong are particularly civilized. I think all police around the world belong to the same species. And it's just that I think looking at the essence of our system here is that if they're involved in irregular practice, or put it this way, if they are involved in brutality, if found out, they will have a price to pay, and often it could be a huge one. So I think this is why torture, under the system, is a rare or even non-existent issue. Ladies and gentlemen, I think for the purpose of this sharing of our experience, I should introduce you in a nutshell how our system works here. Earlier, I prepared an outline featuring some important parts of our system, including civil and criminal procedure, natural justice, our legal system, and our judicial system, and our legal profession. Well, I think we all understand that the judiciary, as well as the legal professions, are the cornerstone of a sound legal system. In Hong Kong, we have a credible judicial system. Here in the city of Hong Kong, we have a population of 7.3 million. Altogether, we have just over 8,000 lawyers, and we have nearly 200 full-time judges. Now, when I say full-time judges, because we do have part-time judges, quite often the judiciary will appoint some lawyers, most of them barristers, to sit as temporary judges to help them out when they're too busy. So we have approximately 200 judges sitting in all levels of courts here. Now, I say this is a credible judicial system because in our history, judicial corruption is almost unheard of. We have never had a case of a judge being arrested, prosecuted, and found guilty of corruption. Now, this is not, again, non-existent in our history. And in fact, the judges in this city, they are very worried of protecting their image. So they maintain very low key. Of course, sitting in a court, the judges are assuming some high profile position, but in their private lives, most of them maintain a very low profile status. They don't talk much and they behave themselves, and they quite sometimes jokingly we remark that they won't appear in places where their wives don't want them to be in, and so they're very careful about their images, and of course earlier Bishop Francis mentioned about the remuneration of these legal persons, and of course they have all receive very high pay here. And I can give you a figure for those judges sitting in the lowest court, in the magistrates court level. Their monthly salary is in the region of about just over $10,000 US. And for the judges sitting in the highest court, I think their monthly salary is probably, we're talking of over $13,000-14,000 US a month. So reasonably high here, but it's not that because they receive a high remuneration, they stay away from corruption. And I think our system, looking at our system itself, in essence, there is this kind of protective mechanism so that the judges will not, or put it this way, people would not even dream of bribing their way through this court system in order to achieve their target. They would not even dream of bribing the judges to get what they want. So this is, I would say that there's this kind of immunity system innate in our legal system, so that corruption in this system is almost non-existent. I would say actually non-existent as far as the judges are concerned. Now, besides, I think we have a legal profession, which is largely, again, a credible profession. In Hong Kong, we still have two divisions of lawyers. I am a member of the Bar Association, a barrister. We have now 1,100 members. Then we have members of the Law Society known as solicitors. Now they have close to about 8,000 members, 8,000 solicitors. I think Jack Clancy was here yesterday. He is a member of the Law Society. So we have now over 8,000 lawyers in this city, and we are largely respected by members of the public. And so I think this is a rather trustworthy profession. And in fact, the lawyers here are independent. The government is nowhere near controlling us. We are self-disciplined, we are self-regulated, and we actually take care of our own affairs. But on top of that, what's important is that the legal profession, the two legal organizations, the lawyers' organizations, impose rather stringent rules and regulations, including code of conduct, upon their members, so that we all know how to behave ourselves. And by doing that, we are able to win respect from from the public. And in fact, of course, we all know that Hong Kong is, we call it a common law system. Now, common law system means that the lawyers are playing a very active role in court, and the judges are sitting there as an adjudicator, as an impartial, neutral, passive adjudicator. And so the lawyers, therefore, will have their full autonomy to represent, to act for their clients. Now, this is essential. I mean, in terms of defending the citizens' rights, because when the public have any need to seek legal service, the first person they can think of must be the lawyers. And as long as the lawyers have this autonomy and this trustworthiness, the public will, without hesitation, go to the lawyers to seek their service. And also, now since as I say, the government will have no control on the lawyers, we therefore will fight the case, we will act for our clients without fear. And since we have a rather stringent restriction and code of conduct behind us, therefore we can fight the case without prejudice and fairly. And now, given this background, therefore, if anyone who complains about having suffered, for example, police brutality, of course they are absolutely free to go to a lawyers, and this matter will be addressed openly, publicly, and most importantly in court. And I mean, the best way to protect someone's right is, of course, one is procedure, or due process. Two is remedy. Now, with due process where we can follow, and also remedy open to us, and this, in my view, is the best way to protect our basic human rights, our civil rights under the law, and also it must be I mean, the best way to protect against torture. So this is a brief summary of the background. Now, of course, looking at the outline, you will see that we have civil procedure and we have criminal procedure. Now, for those who may not be familiar with the common law system, perhaps a brief introduction may be essential. Now, if I may start with firstly the criminal procedure. Now, first of all, I think, of course, criminal procedure starts from police investigation, and any misconduct or any irregular practice will start from the stage of arrest and investigation. Now, the system here is that when someone finds himself being approached, investigated, or even arrested, taken into custody by police, they have every right, infringible right, to seek a lawyer's participation and assistance. Now, this is a constitutional right which the police cannot resist. In other words, if a police comes down on me and seeks information from me, even before arrest, first of all, the police must caution me. We all know the meaning of caution. That means I am now arresting you on the ground of so-and-so. You have a right not to answer my questions. You have a right to get a lawyer. But whatever you say, it may be written down and may be used as evidence against you in court. Now, this is the basic form of a caution. Now, in the absence of a caution, any reply or any verbal communication from the suspect or arrested person cannot, now I emphasize, cannot be used in court as evidence. In other words, any uncautioned communication is inadmissible as evidence. So that's, of course, this becomes, of course, a very unattractive way to get confession from someone without reminding this person of his right under the law. So number one is caution. Now, after caution, the arrested person, the suspect, of course, has every right to invoke his right. For example, all right, if you are reminding me that I need not answer your question, so I remain silent. And you are telling me that I have a right to get a lawyer. Okay, please, I want a lawyer. And the police cannot decline this request for a lawyer. And of course, in every police station, there is a copy of a thick volume of lawyers' list there. It has to be made available to all the people. Now, you need a lawyer. Do you have any lawyers in mind, or do you have the telephone? No, I don't know any lawyers in the city. Okay, here is a list, as thick as a telephone directory. The person can call anyone or call his family to look for him a lawyer. Now, this is his right. And also, in every detention room or interview room in a police station, there's a practice of putting on the wall a large notice board showing a suspect's rights. Or there are over 10 entries there. For example, you have a right to get a lawyer, you have a right to ask for food and water, and if you are tired, you can ask for time to rest, and you can make a telephone call to your family or any persons you wish to. You may call a lawyer, and if you need assistance, you can ask for a lawyer's list. So in a room there is this kind of a notice board, and also as a way actually not only to protect the rights of the person, it's also a way to protect the police from subsequent complaint. That is, when an investigation begins, the police will not only repeat the caution, but also produce a piece of paper with similar rights of the detainee printed on it, and ask the person to read and sign it. And then the police will also countersign it as well. Then the police will keep it. Now, this is the way to show, in case of subsequent proceedings, that the suspect's right has been made known to him. And he has signed and he has confirmed his knowledge of it. Now, this is the way to protect the police against subsequent ill-founded complaint. So this is a practice, and we have adopted for many years. And this piece of paper will also go on the police investigation bundle. And subsequently, if this person is charged, the defense lawyers may demand disclosure of all the documents, most of the time including this so-called notice or written notice of the detainee's right, so that the defense team will check whether this suspect at the time of investigation has been shown his right or anything like that. Now, a bit of my personal experience. This is this. I remember when I began my practice in the early 90s, in handling a criminal case, I did have a significant number of complaints about police malpractice, not necessarily physical violence, but malpractice, including what? Including such as, for example, now this is still common these days in Hong Kong. The police, while investigating a suspect, use dirty language, swearing, or impolite, manner. Okay, this is a subject of complaint. And sometimes the complaint would be, for example, some sort of enticement, such as, well, this is a minor matter, just admit it, tell us everything, and we'll give you bail, and we won't charge you. If not, then we'll go and search your house, and we'll get your parents in, and so on. Now, this kind of verbal threat. So my experience, my past experience, was that lots of complaints were not necessarily about brutality, but this sort of manner. But so strictly speaking, this doesn't fall in the category or definition of torture. But this is a subject of complaint, and this could form a good ground to exclude any confession. Because if you construe the words of the convention strictly, actually any way causing the suspect to make involuntary confession is subject to exclusion. It could be excluded. So as a criminal practitioner, we'll take instruction from our client about the police practice in every smallest detail. Now, physical brutality was rare to start with, not because the police here were particularly civilized, but because it could easily be found out. They could not hide it. For example, in our system, any suspect could only be detained for usually 36 hours, if need be, up to 48 hours. In other words, within 48 hours of investigation, either the police give him bail, release him, or take this man to court before a magistrate and apply for an order to remand him in custody. In other words, this suspect cannot be locked up in a dark cell for up to beyond 48 hours. In other words, within 48 hours, come what may, he will be either released or go before a magistrate where he can voice out his complaint. In other words, any for example, malpractice cannot be buried longer than 48 hours, and it would be far too risky for the police to adopt this kind of practice. And of course, any remand beyond 48 hours must be unlawful, and this is a serious matter. I've never heard of that, because any remand beyond 48 hours, I would imagine the remedy open to the suspect must be a habeas corpus. In other words, an order for his immediate release, like that. So I think the system is such that therefore it's too risky a business for the police to engage in any malpractice. So this is something perhaps we can give further thought on. Now another thing is, now that's interesting, that is that if someone is arrested, taken to the police station for investigation, in other words, he will be in the hand of the police for up to 36 or not longer than 48 hours. It doesn't mean that the police can do anything they like while keeping this man in the police station. No, the answer is no. Because the practice, and this is a mandatory practice, that as soon as a suspect is taken into the building of a police station, his record will go on, they call it a logbook, colloquially, a logbook. In fact, this is a record book, a big one. The officer on duty must keep a record. Okay, what the name of the suspect, time, taken into the police station, and he will be in the hand of the duty officer. And if later on the investigation officer would want to interview him, put the questions to him, then this officer must sign on the logbook, on the record book, the time. For example, 30 minutes after taken into the police station, must sign, put down his name, the time, and into which room he was brought to. And then after investigation, this suspect must be taken out from the room and return his body to the officer, and the duty officer will again enter a record. In other words, we call it a movement record. If he was taken from the detention room to the investigation room to the interview room, then at some stage he was given some food and water, and at some stage he requests to go to the toilet. Now it has all go into the record book. We call it the movement record. Now, the purpose of this is to show, if there is any subsequent purpose, that he is being treated in a civilized manner. He is being given treatment as human being deserves. And if there is any danger or any complaint of torture, maltreatment, the defense lawyer will request inspection of the movement record. And from that, it will shed some light on the likely manner of him being treated. So this is, I think, one way to increase the risk of the police using torturous manner upon a suspect. So now, by looking at that, one will immediately see that the whole purpose is to make this system as transparent as possible, as accountable as possible, as traceable as possible. Now, so that will enable any person who complains of a malpractice to lodge a complaint and seek remedy. And there is, of course, we call it a disclosure system. Now, this disclosure system is this. There is a fundamental common law principle, that is that the burden of proof of an offense lies upon the police. The defense need not prove anything at all, except one thing, we call it alibi. Alibi means a kind of evidence which shows that you were not there at the time of the alleged offense. Now, since the police or the prosecution has the sole duty to prove, that must include the whole course of investigation. if there is a complaint, now under the common law system, if there is a complaint of maltreatment, brutality, or even torture, the burden of proof must lie upon the prosecution to prove that those allegations were unreal. No such thing ever happened. No torture, no violence, no brutality, no mental torment, nothing like that. Now, since the burden lies upon the prosecution to prove absence of malpractice, this is absolutely essential upon the prosecution, therefore, including the police, to keep a record. And of course, now it's becoming more popular now that investigation is always performed under a video camera. In other words, we are now keeping, most of the time, in particular, some more serious offenses, a video record of investigation. And usually there is a room in each police station, a small room with a table in a triangular shape, I don't know why. And then you have two police officers sitting there, and one side for the police for the suspect, and if need be, on one side there's an interpreter in case he speaks a different language. And then there's a camera showing the meeting and showing the clock, showing the time of the room. And there will be three copies of the video. After conclusion of the interview under camera, one copy will be kept by the police, of course. One will be handed to the suspect, because an investigated person is entitled to a copy of his interview record, be it written or video. So one copy of the video record must be given to the suspect, and the third one usually goes to the prosecution, to the in Hong Kong, that is the Department of Justice, which is responsible for all prosecutions. Now, so this is the investigation stage, and of course, by listening to the presentation so far, one will immediately know that there must be a purpose for torture, and majority of the cases about torture, about investigation and eliciting confessions from an arrested person. So therefore, I think any protection against torture must focus on the investigation stage. And of course, in Hong Kong, the police and the prison regimes are two different departments. I don't know the position in other countries, but in Hong Kong, when a suspect is being remanded in custody, usually he cannot be remanded in the police station. And besides, in fact, the police don't have the facilities to keep someone in the police station for longer than 1 or 2 nights. Usually, a detained person will be transferred to either the reception center or the prison, which is actually operated by in Hong Kong we call it Correctional Service Department, which is actually the prison authority. In other words, the police and the prison authorities are two different departments, and they are not, subject to each one's control. So this is another way, therefore, to protect, the safety, to ensure the safety of a detained person. And if in future the police wish to, for example, investigate or interview the detained person again, usually these police officers will have to travel to the prison. They have to show their identity. They have to check in and then interview the person in a particular room, and again, of course, monitored by the prison officers. And upon completion of the interview, they check out again in usual manner. And my personal experience is actually that the police officer interviewing a detained person is no different from what the lawyers do. Quite often, when I go to interview my clients in prison, quite often I check in together with the police officer who also want to check to interview the detained person. So therefore, the police, of course, have no way, therefore, to engage in any malpractice, because they are, in the territory of the prison authority. They can't do anything not permitted by law. So this is how our system works. So to ensure that everything is done properly. But I think most importantly, I think the best way to remove any risk or minimize the risk of torture is the judicial function. Now, just imagine, the purpose of using torture or violence to elicit evidence is for the purpose of investigation. But imagine if there's such a product of investigation after using violence is liable to be excluded by the court. Then what's the purpose of doing that? So this will serve to discourage malpractice if we have a workable court system. In common law, there is a procedure in our criminal court known as voir dire. Sounds like a French word, voir dire, which is, you can call it a trial within a trial. This is this. When the prosecution seeks to adduce confession evidence in court against a defendant, and the defendant raises his hand and says, I object. This evidence is unfair because this was obtained under violence or oppression or oppressive manner or unfair manner. I object. Okay? Now, the court has no alternative but entertain this objection. What will the court do? The court will therefore, in the proceedings of the criminal trial, take up what we call a procedure called trial within a trial. That is to determine the admissibility of this piece of evidence known as confession. And in a jury trial, usually this trial within a trial, this voir dire will take place before the jury is impaneled. The jury will not hear any argument about this dispute over admissibility. The jury can only hear admissible evidence. Therefore, in a jury trial, when the defense raises the point of inadmissible confession, then the judge will immediately proceed to start a trial within a trial. And that is where the police officer will find most unbearable. Because in a trial within a trial, now, briefly, this is how the trial within a trial is conducted. The defense will inform the court. In our practice, we'll put it on a piece of written submission outlining the gist of our complaints. We'll show the court a piece of written submission. We'll also provide the prosecution a copy of my written submission. I say that the accused opposes the admission of his confession allegedly made, for example, on the 1st of June 2013, because at the time of arrest, he was threatened verbally by 2 police officers. And when taken back to the police station, he was pushed into a room. And inside the room, he was roughed up, and someone threatened to slap his face, although it never landed on his cheek. And then they swore, the 2 officers swore at him and then threatened to go and search his house, arrest his whole family, and so on and so forth, and threatened to also investigate his workplace, including his employer and so on. And under this pressure, he agreed to cooperate with the police as they wished to, and said everything they wanted him to. Okay, now, for example, this is the gist of the complaint. Now, since, as I say, the prosecution has the duty to prove absence of oppression, absence of brutality, absence of violence, then since the defense now contend the 2 officers are doing this and that, the prosecution will then ask the defense, you are making allegations against 2 police officers. Who were they? The defense, the accused person said, I don't know him. I don't know their names, nor their service numbers, but I recognize their faces. What must the prosecution do? The prosecution will therefore inform that team of police responsible for the investigation of the case, and that team of the team commander will bring the entire team of officers to court for the accused to identify. Now, this is really, really onerous. That team of officers could consist of 15 persons. Okay, all 15 persons must come to court, and they will line up in front of the accused as if they were the suspect in an identification parade. And the police and the accused look at all these 15 officers. Oh, I recognize him and him. All right, these two. All right, what's the name? Okay, the defense will then get the names. Okay, the other 13 can go. Okay, I want these two because the defense counsel will have to put question to these two officers. So these two officers must stay in court, but outside the courtroom, waiting to be we call it grilled. Now, and when the first officer comes into court in the absence of the jury, but in the presence of the judge, the officer has a duty to tell the court the manner in which he performed the arrest, investigation, and handling of the suspect. And after that, of course, defense counsel will put a lot of difficult questions to this officer to shake his credibility and to try to achieve what they want to achieve by showing the court that, in fact, he used irregular practice, some malpractice, unfair manners in doing that. So two officers will be cross-examined, and then the party will make submission saying that, so this and this is this, and those are the facts. And we ask the court to exclude the alleged confession. Now, so this is, we call it a trial within a trial, and it is entirely within the power of the judge whether to accept the case or not. So after determining the admissibility of the evidence, the trial will proceed. Now, looking at this rather cumbersome, rather onerous proceeding, one will immediately see that it actually puts a lot of pressure upon the law enforcement agents or the police or ICAC or the custom officers to engage in this sort of malpractice, because they will become a subject of investigation in court, and if the allegation is truthful, there is a danger that they will be subject to disciplinary proceeding internally. And also, as I say in my outline, in future it is absolutely open to the accused person to seek remedy against those officers who use violence, such as damage or compensation. And in Hong Kong, it happens. And it happens more than once. And actually, it happens a few times over the years, that those people who complained about police violence have the case proved in a civil court, and therefore the government will have to pay them damage. And at the same time, of course, the officer's career, again, will be damaged. So this is a price to pay. Therefore, as I say, the system, the legal system, or the procedure, do play a very important role in protecting the right of the complainants in case of violence. But of course, one will, as I say, one will immediately look at the fact that we have a credible, independent judicial system, and we have a trustworthy and usually largely respectable legal profession who have no fear in defending and in upholding the rights of a member of the public who have a genuine case against the government. Now, so this is of course a general introduction of our system, and now earlier I mentioned the convention. I say CAT it's an unfamiliar area in Hong Kong, thankfully. But as I say, we do have people in Hong Kong from other countries fighting against repatriation by the Director of Immigration. And under Article 3 of the Convention, when we repatriate someone, we have to make sure this person will not return to a country where there is genuine fear of persecution and torture in particular. And this person, if, being subject to the Director of Immigration's order to be expelled from Hong Kong, will have a right to claim, to appeal. Now this appeal, we call it a Torture Claim Appeal Board, which is an independent body to entertain this kind of claim appeal. And I actually have a handout illustrating the guidelines of the procedure. Now, including, most importantly, a appeal person is entitled to legal representation. And I think this is a very, very impressive mechanism. That is, even a foreigner in this city fighting against repatriation is entitled to representation. In fact, nowadays we have over 1,000 lawyers in our profession signed up to represent those people, and they actually have pay. It's under the legal aid scheme. They have pay, and every year I think meanwhile we are representing a few hundred appeal claimants in this sort of appeal.